Hey everyone, Ali here. So let's talk about non-competition agreements because we are getting a lot of questions in this area as it's becoming more and more of a hot topic, if you will. So as many of you know, non-competition agreements or clauses are very state specific. In other words, some states allow them, some states do not allow them. And usually, if they allow them, there's a certain, radius that is considered reasonable. In states that don't allow them, no radius is reasonable. It's completely disallowed. So it's important to keep that in mind. Now, that being said, there are three situations where non-competition agreements really come into play, and we're going to talk about those. So the first one is an employment agreement. So that is usually the first place that people get an experience with non-competition agreements. The second place is when they're signing a contract, when they're selling their practice. The buyer usually precludes the seller from competing against them. And then the third thing is when they're in a partnership. If they're in a partnership, then in those scenarios, a covenant not to compete or a non-competition agreement kind of comes into play. So we're going to talk about those three scenarios. We're going to talk about who benefits from them. We're going to talk about what to consider when you're doing one, and then what the drawbacks potentially are and how to avoid them. So the first, as I mentioned, is an employment agreement. Now, in an employment agreement, the employer is trying to prevent the employee from competing against them, and which is reasonable. And in those scenarios, they're trying to protect against either a physical, competition. So in other words, the employee doesn't open up, close to their office. But also, there's a way of protecting against the employee taking patient charts, taking staff members, taking secrets on marketing and other things. And so if drafted carefully, those things can be protected. Of course, like as I mentioned, in some states, you can't have a radius where someone you're preventing someone from competing against you around a certain radius. That would be considered unlawful. So California, for example, is one of those states. But very many other states like Hawaii, Washington, Texas, New York, whatnot, Nevada allow for a reasonable distance from the office where competition is allowed. And so it's important to keep those in mind as you're drafting these, because if depending on the state that you're in and depending on the radius that you put, these terms, if they're drafted too broadly, might invalidate the contract on its face. And so it's as if you didn't have a contract at all. So it's important to kind of keep that in mind. Now, that being said, like I mentioned, you can protect your intellectual property, so you can protect against theft of patient records. That might also, by the way, be a HIPAA violation. You can protect against theft of employees even. And so there's strategies around that that we can discuss with you if you choose to put that in there. But those are all really good ideas to do. And so the next is when it comes to partnerships. Now, partnerships, their covenants not to compete are allowed amongst partners, and the reason it's allowed because you are in a partnership, so it's a different relationship than an employee-employer relationship. And so within a partnership, you can prevent your partner from competing against the practice that you're in. So you can say, okay, neither one of us can open another office within 5, 10, 15 miles. If you leave the partnership, you can't practice for 20, 25 miles, something along those lines. Again, these are just examples I'm giving. The mileage really depends on whether you're in a rural area or you're in a big city. Those numbers absolutely, matter or those factors matter in terms of the mileage that you're setting. But in a partnership, it's allowed and it should be documented. A lot of times, we see partners, maybe they're struggling in the initial years and they go moonlighting, and then that impacts the practice. So you want to be very clear about what's allowed and what's not allowed. Now, the most common example when the non-competition agreement is allowed and is highly encouraged occurs when someone is selling a practice. The buyer can prevent the seller from competing against them. And it makes sense when you think about it from a societal perspective. we don't want people to sell their practices and then go open up down the street and take all the patients back. That would discourage the sale of practices. It would lead to a lot of litigation, and quite frankly, it's just unfair to the buyer who spent a significant amount trying to buy the goodwill. And so there, a reasonable non-competition agreement is allowed. We've seen it anywhere from 5 to 25 miles, usually for 5 years. The distance is again based on where you're located. Are you in a downtown area or you're in a rural area will make a big difference. Where the patients come from is also very important in that scenario. So non-competition agreements are important. They are a vital part of a lot of contracts. It does depend on your state, and also depends on the kind of transaction that you are entering into as to whether they are legal or not. It's not something, as I mentioned, that you should try to do on your own without some professional help, primarily because if it's done incorrectly, there's a lot of there's a big chance that it could invalidate the entire agreement. If you have any questions about them, please don't hesitate to reach out. Thanks.